Hello dear students, welcome to IAS Viewpoint, the point of success. Democratic. Another word is democratic. This word comes from two Greek words, demos and kratia. Demos means people, kratia means power or rule. Generally, democracy is of two types, direct democracy and indirect democracy. India follows indirect democracy. Again, it is classified into two types, whether it is a parliamentary democracy or a presidential democracy. We follow parliamentary democracy. Indirect parliamentary democracy. Indirect is also known as representative democracy. Why is it called representative democracy? Because as all the people cannot take part in the daily activities, we represent or we elect our representatives and they carry out the functions. Countries like the United States of America follows presidential form of government. What is direct democracy? Direct democracy follows the principles of referendum, initiative, recall, plebiscite. What is referendum? The proposed legislation is referred to the electorate for direct votes. Suppose a legislation is to be made, it takes votes directly from people. But in indirect democracy, legislation is made in the parliament by the elected representatives. Then, initiative. People can propose a bill to the legislature for enactment. Whereas in India, we have a legislature, we have political parties, we have representatives who will propose. The bills may be private or public, but they need to be the members of the parliament or the members of the house to propose. But in direct democracy, it is not so. And recall, voters can remove a representative or an officer before the expiry of his term when he fails to discharge his duties properly. Plebiscite is a method of obtaining the opinion of people on any issue of public importance. Of course, indirect democracy has another means of collecting public opinion, not through votes like it is done in direct democracy. Ours is a parliamentary democracy. Representative is nothing but indirect parliamentary democracy. Elected representatives form the government. They make laws. These elected representatives make laws. We have universal adult franchise. Everyone who crosses the age of 18 is granted a right to vote, and periodic elections every 5 years. We have elections, independent judiciary, and it doesn't depend on the legislature or executive, and rule of law, equality before law are followed. Hence, we call ourselves as representative parliamentary democracy. This is the kind of democracy which our preamble envisioned. There is another form of democracy followed in India. That's economic democracy. What did Supreme Court say about this economic democracy? In 1997, in Samatha versus State of Andhra Pradesh case, the Supreme Court observed the Constitution envisions to establish an egalitarian social order, rendering to every citizen social, economic, and political justice in a social and economic democracy of the Bharat Republic. Social and economic and political justice in a social and economic democracy. It implies that the Constitution ensures economic democracy along with the political democracy, not just the democracy existing in polity, but even in economy. What are the features of this economic democracy? Economic democracy is a system where people share ownership over the resources in their communities and participate equally in deciding how they are utilized. Public are empowered to make decisions as far as the means of production are concerned. It's a socio-economic philosophy. Economic democracy is a kind of socio-economic philosophy that vests power in large group of public stakeholders that includes workers, customers, suppliers, neighbors, and the broader public. Individual economic rights, diverse forms of democratic collective ownership of companies, and the need for greater public participation in economic decision making. These are the factors which exist in economic democracy. If we observe the mainstream media, whether it is print or electronic media, or even to certain extent social media, we don't really observe economic democratic deficiency. See, economic democratic deficiency is not discussed much. It is not debated much. There's a lot of debate on political democratic deficiency, but this aspect is neglected by mainstream media as well as even the social media to certain extent. What Dr. B.R. Ambedkar had to say about economic democracy. Let me just read as it is the statement. Dr. Ambedkar, B.R. Ambedkar says, political democracy cannot last unless there lies at the base of its social democracy. What does social democracy means? It means a way of life which recognizes liberty, equality, and fraternity. The principles of liberty, equality, and fraternity are not to be treated as separate items in a trinity. They form a union of trinity in the sense that to diverse one from the other is to defeat the very purpose of democracy. Liberty cannot be diverse from equality. Equality cannot be diverse from liberty. Nor can liberty and equality be diverse from fraternity. Without equality, liberty would produce the supremacy of the few over the many. Equality without liberty would kill individual initiative. Two aspects are highlighted by Dr. B.R. Ambedkar when he talks about economic democracy. Liberty, equality, fraternity. See, if we look at the triangle, liberty, equality, fraternity, we should see or look at them as a trinity, one and the same. It's a one, it is a one with three phases. We cannot separate liberty, fraternity, equality into three aspects. They are one integrated, inseparable trinity of union or union of trinity. The second aspect he emphasizes is, suppose if you take away the liberty, only equality is stressed, it would kill initiative. See, there are people who are initiative, capable of doing different things. We cannot put everyone on equal platform. At times, if we bring equality to certain extent, it will kill initiative. And another aspect, suppose equality is not followed, exclusive liberty is given. That means only a few will come up, only the property, the resources will go to a very few, and they will try and dictate the terms, and the future is determined by this a few people or a very limited people. So it is a combination. It is to be understood in light of all these three concepts: liberty, equality, fraternity. Three go together. And republic is another term. It is originated from Latin words res means entity, publica means public. A republic means It is public affairs, it is not private affairs. It is not a private concern or private property of an individual or group of people. It is something to do with the public. It is something to do with the welfare of the complete group of the people, not a particular section of the people. A republic has to be headed by an elected person. The head of the state should be elected, whether it is direct or indirect. And head of the state should not be a monarch or king or queen. And they shouldn't be enjoying hereditary rights. The rights should be derived from a source, not based on hereditary. And another thing, the sovereignty with the people and not with the king. Who are sovereign? People are sovereign. People are powerful. It's not the king. There is no privileged class. There is no a particular class who enjoys privileges, who acquires powers of king and queen. There is no particular set of people, separate class of people. Public offices are open to all. If these features are followed, we call that country as republic, and India is republic. We follow all these aspects as enshrined in preamble. Another term used in the preamble is justice. What does justice imply? It implies freedom and opportunity for all, giving every person his or her due. It's a prevalence of rule of law existing across the country. It's a kind of a moral virtue of character. Justice is not just something to do with law, it is also something to do with morality. Okay, it's a kind of desirable quality of political society. If a political society has to progress, it has to be a just one. Justice needs to be given proper place in order to prosper the society, to prosper and grow politically, economically and socially. Justice should be applied in all the decision makings, whether it is ethical decision making, social decision making, or whether it is scientific decision making. Even to certain extents, even in science, justice has to be included, right? This sentence has got far-fetched meaning, but I'm saying to certain extent. And Immanuel Kant, one of the German philosophers, one of the great philosophers of his time, he says justice is inextricably bound up with obligations with which we can rightly be required to comply. See, there are some obligations and there are some compliances. He says it is the compliance of the obligations rightly. Next, to say that we have duties of justice to other person is to indicate that they have rights against us and we should perform those duties. So that duties of justice and rights are correlative. What he says, let's say a person X has got rights. This person has got some rights. It implies there are some duties on the aspect of Y. Y has got duties. It's vice versa as well. Let's say Y has got certain rights and there are some duties to be fulfilled by X. It is correlative. Rights of one individual and duties of another individual. Rights of state, duties of individual. Rights of individuals, duties of state. They are all correlative. Then after completing all this, justice can exist. That's how Immanuel Kant opines. Justice was secured through fundamental rights and directive principles of the state policy. The ideals of justice, social, economic and political, were borrowed from Russian Revolution. We follow distributive justice. What does distributive justice mean? Combination of social justice and economic justice implies distributive justice. What do you understand by social justice? There is no discrimination based on caste, color, creed, sex, race. Equal treatment of all. No privileged class. There is no some kind of class where we treat separately. The royal family, this family has to be treated separately. No, there is no such kind of discrimination. However, if the principle of social justice needs to be fulfilled, there should be positive discrimination towards backward classes. If there are some segments, some classes of people in the country backward, they by the very inherent nature of their birth or society or the class or the family, the backward, the state needs to discriminate them positively to fulfill the social justice. What is economic justice? Elimination of glaring inequalities. There shouldn't be one fellow enjoying 90% of their property and another beggar just living there, not even enjoying 1% of the resources. There shouldn't be glaring inequalities. The moment you look at it, the inequality shouldn't be. There is some sort of inequality exists in any kind of society, but the gap shouldn't be very vast for the principle of economic justice to be fulfilled, right? And there shouldn't be monopoly over the production. This is very important. If you want to fulfill economic justice, if a state has to fulfill this principle, there shouldn't be monopoly of means of production, especially the means of production which are required for the survival of the public. What is political justice? We all understand it. It's very simple. That equal political rights, equal voice in the government. See, equal political rights is well known, but this point, remember, voice in the government. It shouldn't be that only some class of people enjoying the political rights, only their voice is heard all the time. There should be voice in the government for everyone. There shouldn't be anyone voiceless in the society for the political justice to be fulfilled. There should be free and fair opportunity to the people for participation in the political process. Nothing should be hindrance to take part in the political process for any citizen. Then these ideals can be fulfilled. Our preamble envisions that we need to have the social justice, economic justice, political justice. The state should follow all these principles. Another important concept in the preamble is liberty. Liberty means freedom. Freedom to do whatever one wills. Of course, with some kind of restrictions. These ideals, the ideals of liberty, equality and fraternity, were borrowed from the French Revolution, 1789. Political liberty and civil liberty, state of freedom, opposed to political subjection. These are the features. See, there should be freedom politically and as a person in his civil life. There should not be any slavery. There should not be any political suppression and subjection. Freedom to do what one wills. Suppose if I want to enjoy one kind of life, I should have that freedom. Absence of unreasonable restriction is considered as liberty. See, it cannot be unqualified freedom. Freedom will always have some kind of reasonable restrictions. If reasonable restrictions exist, we can still call it as liberty. But there are unreasonable restrictions, then we cannot call that state has got liberty or people are enjoying freedom or liberty. A liberty should not encroach the liberty of the other person. So your liberty ends where the other person's liberty begins. It's like qualified and quantified, and just that it should not have unreasonable restrictions. Liberty of thought, expression, belief, faith and worship is provided through fundamental rights in our Constitution. They are enforceable in the court of law, and they are explicitly expressed in the fundamental rights. Equality is another wonderful term incorporated in the preamble. All the aspects related to equality are resembled or expressed in the Constitution. Our Constitution embraces three dimensions of equality: civic, political and economic. The civic equality is expressed in the Constitution in the Articles 14, 15, 16, 17 and 18. Article 14, equality before the law, prohibition of discrimination on grounds of religion, race, caste, sex or place of birth, equality of opportunity in matters of public employment, abolition of untouchability, abolition of titles. All these articles speak of the civic equality. Political equality, Article 325, 326 express that no person is to be declared ineligible for inclusion of electoral rolls on grounds of religion, race, caste or sex. Then elections to the Lok Sabha and the state assemblies to be on the basis of the adult suffrage. Next one is economic equality. Economic equality is given in Article 39, a right to an adequate means of livelihood and equal pay for equal work for both men and women. If we observe, these are enforceable, the fundamental rights, the civic equality. Political equality, enforceable, Article 325 and 326, enforceable in the courts of law. Next, even though Article 39 comes under directive principles of state policy, there were legislations made towards that end, and this aspect is enforceable in the courts of law through legislations. Please understand. Another term which was added through 42nd Constitutional Amendment Act in 1976 was fraternity. Fraternity means brotherhood. It assures the dignity of the individual, unity and integrity of the nation. Psychological and territorial dimensions of national integration are related with the idea of fraternity. Personality of individual is sacred, says K.M. Munshi, the member of the drafting committee member. He says that personality of an individual should be treated with utmost importance. Here, the element of fraternity involves, unless you treat your own neighbor as your own brother or sister, it's very difficult to respect the personality of that individual. There is no place for communalism, regionalism, casteism, linguism or secessionism. Right? This is expressed, fraternity is expressed through directive principles of state policy. It was expressed in Article 51A, fundamental duties. It shall be the duty of every citizen of India to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic and regional or sectional diversities, to renounce practices derogatory to the dignity of women. Dear students, one of the highly debated questions is our preamble part of the Constitution? Is it part of the Constitution or not? We have three judgments: Berubari Union case, Kesavananda Bharati case and LIC of India case. There are other cases as well. Three important cases where this aspect was touched upon. Though the cases were on different subjects, they dealt upon preamble, just to fall back on preamble at various moments. right? The cases were not about the preamble. Probably this case was a Birubari Union case, was about the enclaves near the border between India and Bangladesh, then Pakistan, right? But the aspect of preamble was touched in these cases. In 1960, in Birubari Union case, the Supreme Court said preamble is key to the mind of makers for interpretation when articles are ambiguous. However, preamble is not part of the Constitution. The court said, or rather, it attributed the features of interpretive preamble. Ours is an interpretive preamble where the laws are ambiguous, we can fall back on preamble. However, it is not part of the Constitution. When it is not part of the Constitution, it implies that we cannot make amendments. However, in Kesavananda Bharati case, 1973, the Supreme Court observed that probably it was an error, and it has corrected that by stating that preamble is part of the Constitution. Remember, this is a 13-judge bench, and this is a Birubari Union case is an 8-judge bench. Kesavananda Bharati case is a 13-judge bench. This is 8-judge bench. The Constitution should be read and interpreted in the light of the grand and noble vision expressed in the preamble. Wonderful. It should be read or reread, interpreted in the grand and noble vision expressed in the preamble. Our preamble expresses the grand vision, noble ideals, noble thoughts. It should be interpreted in light of that preamble. Again, in LIC of India 1995 case, it reiterated stating that preamble is an integral part of the Constitution. At present, what is the opinion? The Supreme Court opines preamble is part of the Constitution. Alright? And if we observe, preamble was enacted after the rest of the Constitution. Probably maybe to follow the complete spirit of the Constitution, to express the essence of the Constitution, they might have enacted at the end of the Constitution. But preamble was enacted by the Constituent Assembly like rest of the Constitution. Remember, very important. Like rest of the Constitution, this preamble was enacted by the Constituent Assembly. The Founding Fathers' opinion, probably that preamble to be as part of the Constitution. Non-substantive preamble. Our Constitution is neither a source of power nor prohibition. We cannot directly legislate based on the preamble certain legislations or rights. It should be supported by part of the Constitution. There is no direct source of power. There is no direct source of limitation. There is no direct source of prohibition as far as a preamble is concerned. It is non-justiciable in nature. It cannot be enforced in the courts of law. Indian preamble is a symbolic and a representative preamble. It is a good interpretive preamble. It can be substantive preamble when there is absolutely no light for the legislation. At times, the preamble may turn out to be a substantive, but in general, a symbolic, a ceremonial, interpretive preamble. Amenability of preamble. Can the preamble be amended? Kesavananda Bharati case preamble is part of the Constitution. When it is part of the Constitution, definitely preamble can be amended. If need arises, it should be amended. Remember Chief Justice, former Chief Justice of India, M. Hidayatullah stating it's a solemn resolve. If at all it has to be touched, a great revolution should come. If at all a change needs to be made, it can be amended, provided that thought should be very noble, very ideal, and it should be very powerful, right? And however, in the very same case, the Supreme Court opined no amendment is done to the basic structure, the fundamental features of the Constitution as contained in the preamble. The concept of basic structure originated from here onwards. Of course, it will be dealt separately, the concept of basic structure, but understand that we can amend preamble, not the basic or essential features given in the preamble. On the recommendations of Swaran Singh Committee, the preamble was amended in 1976, as we have seen through 42nd Amendment Act, and added socialist, secular and integrity to the existing preamble. The preamble has been amended so far only once, that was 1976. With this, we have completed the topic preamble. We have made every effort to touch upon the important ideas related to preamble. In case if we have missed out any important ideas, and if there are any developments which take place or which will take place in the future, we will come up with another video just before prelims as well as mains. And please subscribe to our channel so that you may get the updates. If you really like our video, please press like icon. We are open to the constructive feedback at iasviewpoint@gmail.com. Please do share this video to the most needy people. Thank you.